So, a new case is hitting the Supreme Court that asks a really important question. What are the exact limits that a school can place on a student's speech, particularly when they're not on campus? Now, this is in response to a cheerleader who posted a Snapchat that had some choice language in it, and the school disciplined her over this Snapchat. The Snapchat was not sent while she was in school. It didn't have anything specifically to do with the school or with any faculty at the school. And this is the big question. How much control do schools have over student speech? I'm Nick Ricada of Ricada Law, a small law firm in central Minnesota. I'm a lawyer, but I'm also a legal and political commentator here on YouTube. If you like that type of stuff, hit the subscribe button, hit the notification bell, don't miss any videos. Okay, so I know there's some questions that we have to address here. One, why are schools policing kids' speech off campus is a pretty good question. Two, can schools police student speech at all? And three, if schools can police student speech, where does the Constitution come in and how much protection are afforded to students? These are very, very big questions, and that's why the Supreme Court has taken up this case. But first, let me give you a little bit of background about what happened. I'm using this article from ABC News, and the link to it will be down in the description if you want to go ahead and check that out. But we're going to kind of piece our way through it as necessary. But here's the headline. Teen cheerleaders Snapchat brings Supreme Court clash over schools and free speech. And schools and parents worry the fight against cyberbullying could be harmed by the case. First of all, you need to stop. You need to stop right now with the cyberbullying stuff. This is about protected speech. And as much as people may not like it, bullying is typically protected speech. Now, we're going to get into where that clashes against a school's responsibility to maintain a safe learning environment. However, schools are not social media. Social media are not schools. So we've got some pretty different things going on here, and that is where some of this stuff is going to happen. Importantly, that's a little sub-headline, and none of this case actually involves cyberbullying at all. So they can continue to worry no matter what the decision is, because that worry will permeate until an actual case involving cyberbullying were to go up to the Supreme Court to be decided, because that's a completely different fact set, and some of the facts that are involved in that are extremely critical to the questions being asked. But anyway, here's the story. When 14-year-old Brandy Levy didn't make the varsity cut as a freshman cheerleader for the Mahanoy Golden Bears, she sounded off on social media as teenagers are known to do. She says, "I was frustrated, I was upset, I was angry, and I made a post on Snapchat. I said, F school, F cheer, F softball, F everything." That's the post. Although I think those F's might have had 3 letters that follow each one of them, but I'm not entirely sure that's what's in the what's in the news story here. But I'm guessing it was an F followed by a little more. But that's it. School, cheer, softball, everything. Not a specific school, not a specific person, teacher, faculty member, not a specific classmate, not a specific anything. Just a generalized expression of frustration. And so what was the result of that? When she posted the vulgar message to her friends on a weekend in 2017, she never thought she'd hear about it again. Probably because she maybe shouldn't. But days later, the school accused her of breaching a code of conduct and suspended her from cheerleading for an entire year. So that is the issue here. She made that one tweet, or Snapchat, I should say, a Snapchat sent to her friends. Now, this isn't posted generally like Twitter. It's not the same sort of environment, and it doesn't appear to be targeted at any specific person. This is a teenager, basically shouting into the void and being angry with something that happened. Which I don't know if you guys know this, but most of us are allowed to be angry when something doesn't go our way. So her Snapchat post and the punishment that followed are now at the center of a major U.S. Supreme Court case that tests the boundaries of school discipline and the rights of students to free speech. So, quote, "This is the first time that the U.S. Supreme Court is going to decide whether the rules that apply to kids when they're in school also apply to their speech when they are outside of school," said Sarah Rose, an American Civil Liberties Union attorney defending Levy in the case. Now, she won the lower level court, the district court. She won, and the school was ordered to reinstate her back into the cheerleading program immediately. She won at the appellate court, and now the school has appealed this further. So let's get into some basic things about this case now that we have the background. 1, do kids have constitutional rights while they're at school? Yes. Yes, they do. The court in a famous 1969 decision said the students don't surrender their First Amendment rights at the schoolhouse gate, but that educators can limit speech on school property when it's materially disruptive. It has not been addressed how school-related speech expressed off campus can be handled. And there's a pretty good reason for that. There's nothing about this particular speech that is particularly materially disruptive to the immediate learning environment. We're talking about a 1969 decision. We're not talking about, a student in sending out Snapchats in 1969. In fact, I don't think we have any cases suggesting that students can be disciplined for phone calls between themselves and other students off campus. That would be absolutely silly. So we have to ask why Snapchat is somehow different. This is communication between peers off campus. It's not materially disruptive to the school day. In fact, it doesn't even reference a school by name. It doesn't reference a specific teacher, as I've said a couple different times here. There's nothing that is disruptive about this. Nothing more disruptive than even regular speech at the school. I think the issue that the school took was with the vulgarity coming from a 14-year-old. And while people may take individual umbrage with the type of language that she used, the Constitution protects people's rights to use vulgarity all the way down to the first moments they utter words. That's not some sort of limit on speech that is imposed by the Constitution, or that is not protected by the Constitution, that somehow allows schools to intervene. Now, another fact in this case, which the school is focusing on, is that Levy had signed a code of conduct that would they're arguing it would hold her to a higher standard, that she had to uphold this specific code of conduct, and that if she had made these sort of statements, that was a violation of the code of conduct. Levy disagrees with that reading, saying that her statement didn't violate the code of conduct because it didn't disparage any particular person at the school. It didn't disparage the school itself, and the school wasn't named. None of that actually happened. There was no negativity towards the actual school or the program specifically. Now, there was clearly negativity there, right? Like, she can't shirk away all of that. But she's saying in the absence of the specifics, then she's not actually violating the code. My question is a little bit different. I don't actually see how a 14-year-old can bind themselves in that way. There is no ability for a 14-year-old to contract away their right to speak that I'm aware of. Typically, you have to be 18 years of age. You have to be competent to actually sign on to a contract. So a code of conduct signed by a 14-year-old seems like a mere suggestive agreement, not a binding contract that they would be able to thus take away an actual right. And it is important to remember that this is a right, and because this is a school, presumably a public school, that the school itself is bound by the Constitution as they are a state actor. If this is a private school, we're talking a completely different question that would not be at the Supreme Court right now, because a private school could go ahead and maintain all sorts of policies that violate constitutions. Public schools cannot. They are government actors, and they must uphold the constitutional rights of students. Now, schools infringe upon constitutional rights of students all the time. They do locker searches. They do pat-down searches. They will search backpacks. They will restrict the rights of speech during class time or in hallways or on school property. They can do all sorts of things like that, but all of them must be narrowly and specifically tailored to facilitate a safe and non-disruptive learning environment. They're allowed to get a little more authoritarian than other government bodies when the actual conduct of schooling is taking place and when the conduct in question is disruptive to the ability for the school to do that. Again, either maintaining the safety or maintaining the proper educational environment, we'll say. So if she was in the middle of the lunchroom screaming at the top of her lungs, F school, F cheerleading, there you have a disruptive sort of situation. It can be heard maybe in classrooms. It will be heard by other students. It can cause some sort of expenditure of resources, right? Getting someone to stop the activity that's going on. A school would have no problem restricting that. Where this gets really muddy is how on earth does a Snapchat sent from one student to another in really any context actually disrupt materially the ability for the school to facilitate a safe learning environment? Outside of something like a specific threat of violence, it's a really, really hard question to answer. Because even if there is, let's take this to the way the article is going, even if there's something like cyberbullying going on off campus, and that's not translating to on campus during the school day, the school's ability to interfere or interact with this becomes extremely limited. And students who are experiencing that cyberbullying may have to go through different resources. And that's okay. People have been dealing with bullying for a long time, and when that bullying is happening at the school may have a duty to go ahead and intervene. They may need to facilitate a safe environment for the kids. When it's happening off school, there are other resources that need to be employed, and that is the question here. Why is the school doing this? Why are they taking on this student's speech? This student's particular speech, which I must remind everybody is not cyberbullying in any way. That's a separate question. It's just brought up by the article, not by the case itself. But why are they taking it upon themselves to so thoroughly try to discipline the student, suspending them from a school activity for an entire year because of a Snapchat? To me, it's the overreach of schools, it's the overreach of government, and it is a natural consequence of things, and the Constitution is a bulwark against that and must be upheld for what it is. But those are the questions that are at play in this case. I'll be following along. This is a really, really important speech case, especially in the age of social media, where kids have an until now unprecedented ability to speak out, to be heard, to express themselves. And that expression comes not only with the reciprocal act of being heard, but it also can come with building a platform that can turn into something more than just a mere outlet for their frustrations, right? Social media is a place where people are making careers, and they're actually building and cataloging their own lives in a way that's never been handled before. And for a school to interfere and to intervene and to chill that is to implicate the very rights of life, liberty, and property that are laid out more specifically by our Constitution in things like the freedom of speech. The fact that these students are expressing and interacting and socializing on social media off campus is how they're pursuing their happiness. It is how they're defining their lives, and it is an expression of their own liberty. And so to restrict that by a school because the school merely does not like the fact that she said F school and F cheerleading, that to me is an overreach. But hey, I'm me. I know how I think. I don't know how you think. So drop a comment down below in the comment section. Let me know what you think about this case. I find it to be fascinating. You can check out the article if you want a little bit more information about it, but we'll be watching to see what happens in court, and it should be pretty cool. All right, until next time, peace. Peace.